What's up, everybody? We are talking about an interesting topic today, and that is how stuff gets paid for when you're indigent. And you hear all the time people qualify for a public defender and they can't afford an attorney on their own, so one will be appointed for them. Well, we see in different cases, they still get experts, they still get lawyers, they still have money to spend and costs for cases. My dad was supposed to join me. It looks like he's not going to be able to, but if he does, he'll jump in later to talk about this some. He has more experience dealing with the JAC. I think when we deal with situations like this, it's always interesting because it's taxpayer dollars. And when we talk about taxpayer dollars and we have situations where we want people to get a competent and fair defense, lines have to be drawn. And how are those lines drawn? And a lot of times they have to do with, or they're drawn by lawyers in the state dealing with the public and being part of the communities that pay for these things, that set what the limits are that you can pay experts in criminal defense cases, in court appointed cases, what lawyers get paid in these cases. And, public defenders get paid a salary usually. So that is what it is. Sometimes they can ask for extra money. We're going to talk about a case where that's happening today. And we're going to compare that to the court appointed agreement that Bankowitz entered into with the JAC in order to be appointed to represent people like Sarah Boone. So we're going to talk about how much money they get paid, where it comes from, whether or not you think that's fair. I think we're going to throw up a couple polls about whether or not you think that's enough or too much or not enough. And I think it's going to be really interesting. So hit that like button if you haven't already and subscribe to our page. We are going to jump right into this ex parte response to Bankowitz's request for more money, basically to hire an expert. So the issue here was basically twofold. Number one, they couldn't find an expert for the case. And number two, they finally did find an expert, but this expert charges more than the JAC rates. And so they've asked the court to basically tell the JAC to give Sarah Boone more money to hire this expert. And we know this expert is dealing with battered spouse syndrome. So how does this work? Well, the Justice Administrative Commission has to give their opinion. Do they think that this is appropriate for them to add more money to, or are they going to object to it? Well, let's look into it. The Justice Administrative Commission's, or JAC, ex parte response to the motion for appointment of defense forensic psychologist comes now. The JAC, by and through its undersigned attorney, and files its response to the above cited motion as follows. Number one, Frank Bankowitz, counsel, is seeking authorization for $15,000 at a rate of $400 per hour for the services and $125 an hour for travel time for a defense mental health expert. And we have to remember, this was back when Bankowitz was the attorney of record. He was requesting this. And if her new attorney, I think Winston is his name, if he wants to use this expert as well, then they are going to have to eventually have this hearing. So this is going to be relevant for any expert that Sarah Boone's attorney wants to hire that's at this amount of money, $15,000, $400 per hour. Based on JAC records, the court previously appointed a mental health expert to assist the defense, albeit under prior indigent for costs counsel. So a different lawyer had a different mental health expert, and they paid $7,500 for the services of this expert for services rendered from August 21st, 2020 through April 5th of 2022. JAC also has concerns about the rate requested for this expert. So this is not in a vacuum. The JAC is not saying we don't want to pay for Sarah Boone's expert. It's not what they're saying. They're saying this is too much and we've already paid for one expert. So now you start to understand the problem with changing lawyers, the problem with delays, the problem with changing strategies on a case, and why we talk about how we don't want this to be the scenario for most criminal defendants. They shouldn't go through 7 lawyers. It shouldn't be years and years of delays in their case, because then you get screwed. at the end of the day. Because now they had one mental health expert that was working with one lawyer. Bankowitz was looking for a different. Maybe Winston will be looking for a third. And at the end of the day, the JAC is like, we're not unlimited funds here. And they can actually run out of funds, which is interesting. And my dad was going to talk more about, so maybe he'll come on still and talk some about that. Paragraph 2, the JAC may only pay due process costs as authorized by sections 29007, 2740, 27425, and 2750304 of the Florida statutes, as directed by section 27425 Florida statutes and the General Appropriations Act. All due process services are subject to the Florida statutes and the JAC contract, policies, and procedures. JAC objects to any compensation rate in excess of the established rates, which is exactly what Bankowitz was asking for in this motion. The rate for a psychological examination is a flat fee of $350. So meaning it's not billed hourly at $400 an hour. You can't do 3 hours and bill $1,200 to do a psychological examination. They cap it at a flat fee of $350. Now, there are extenuating circumstances, which obviously they're asking for in this case, so you can go above and beyond this amount, but it's unusual. For other services, the established rates for medical doctors and psychologists are as follows. In court testimony, $170 for the first hour or less, and $170 thereafter. Waiting to testify, meaning sitting in court, $85. Waiting to testify at a deposition, $72.50. Travel time, $72.50. Not, I think it was $125 an hour for travel. Out of court services, $160 for the first hour, $160 per hour thereafter. Not $400. And again, this is the reality of the difference between hiring a private lawyer and having your own money to pick whatever expert you want, pay him $400 an hour, $15,000, whatever it is that you and they agree to and contract for because you want that expert, you think they're the best, and they can charge those rates because they believe they're the best. That is not how the indigent services work when you have court-appointed and JAC-funded lawyers and experts. Counsel has the burden to establish the particularized need for expert services. Counsel's need to show the services are necessary for the defense of the case. Defense counsel also has the burden to establish diligent efforts to obtain services within or closer to the rates established by law. While an indigent defendant has a due process right to the assistance of experts in his or her defense, the right is not unfettered. The right is limited to experts that are relevant and necessary to the defense of the case. The defendant is not entitled to a specific expert or one of his or her personal liking, but is only entitled to the services of a competent expert. And that's important. And anybody that's worked with a doctor, hired a lawyer, any professional accountant, some are good, some are bad. Even ones that might be rendered competent are not the ones that are going to be to your personal liking. But these are the standards here in court-appointed and funded experts and lawyers. As enunciated by the Florida Supreme Court, an attorney seeking due process costs has the burden to establish, 1, the particularized need for the due process services, and 2, the prejudice arising from the denial of the due process services. The determination of whether to appoint an expert is within the broad discretion of the trial court. An indigent defendant must show the trial court that there exists a reasonable probability both that an expert would be of assistance to the defense and that denial of the expert assistance would result in a fundamentally unfair trial. Counsel needs to establish the need for an additional mental health expert where the court previously appointed an expert to assist the defense and that expert conducted an evaluation for the defendant. Due process does not require the state to provide every foreseeable service to the defense. Rather, that the state is only obligated to provide the basic tools of the defense. As the United States Supreme Court has explained, meaningful access to justice has been the consistent theme of these cases. We recognized long ago that the mere access to the courthouse doors does not by itself assure a proper functioning of the adversary process, and that a criminal trial is fundamentally unfair if the state proceeds against an indigent defendant without making certain that he has access to the raw materials integral to the building of an effective defense. Thus, while the court has not held that the state must purchase for the indigent defendant all the assistance that his wealthier counterpart might buy, it has often reaffirmed that fundamental fairness entitles indigent defendants to an adequate opportunity to present their claims fairly within the adversarial system. To implement this principle, we focused on identifying the basic tools of the inadequate defense or appeal, and we have required that such tools be provided to those defendants who cannot afford to pay for them. In light of the services already provided to the defense, counsel has the burden to show the need for a second mental health expert in this matter. Although counsel may prefer the services of a preeminent expert, due process does not require the state to provide services that a wealthier defendant might elect to purchase. If the expert who has already evaluated the defendant can provide competent and meaningful services to the defense, the court should not appoint another expert in this matter. So my question to you all is, do you think this is fair? Do you think this is fair? And just let me know in the chat that they're basically saying you can't have the best expert if you're indigent. You can't have the same expert that your wealthier counterparts may get. We promise a competent expert, not the best expert. Do you think that's fair? Or should the funds be unlimited by the state? There's a good mix here. Mostly are saying yes, fair, more than fair. Yeah, vast majority saying fair. A couple are saying unfair. All right, let's keep reading. Counsel also has the burden to show diligent efforts to obtain services within the rates established by law. JAC would not anticipate paying a rate in excess of $200 per hour for a defense mental health expert absent some specialty that justifies a higher rate. Even if the expert has such a specialty, JAC has concerns about paying a rate in excess of $300 per hour for even a specialized mental health expert. So regardless, this is way too expensive, basically they're saying. Paragraph 4, Section 8, I guess that is, of the JAC's registry contract attached addresses counsel's requirements when producing an expert at higher rates than the established rates. If attorney intends to procure due process services at rates higher than the established rates, attorney must file a written motion setting forth the basis for the higher rate with service upon JAC. Attorney has the burden to establish that the particular due process service is necessary to the defense. My dad just texted me and said he's out, so I will have him. All right, I'm going to get Big George here on this. Told him to join with the link. So here he comes. All right. Attorney has the burden to establish particular due process service is necessary for the defense in the case, and that the attorney made a diligent effort to find service within the established rates. A prior authorization for a higher rate of the same or similar service in an unrelated proceeding shall not relieve the attorney from diligent efforts in the case at issue. In order to obtain reimbursement, the order must contain a finding that the due process service is necessary to the defense of the case, and that attorney made a diligent effort to find the service within the evidence that the attorney sought the services of at least 3 providers willing to work on the case, but none were willing to work within the established rates. So that's kind of the burden to get the additional rates. And I guess they're saying that Bankowitz did not do this in this case. If any due process vendor desires direct payment, the JAC's procedures require the vendor to execute the appropriate contract and following JAC's billing and audit procedures to obtain payment. Pursuant to the JAC contract, any direct payment to a due process vendor is contingent upon counsel providing any and all necessary documentation in support of billing to the JAC in an expeditious fashion. Counsel shall promptly review any billing for direct payment to a due process vendor for accuracy and completeness, and must certify that the work was satisfactorily performed, the services were necessary for the defense of the case, and that the amount billed is accurate. In the event the JAC issues a deficiency notice regarding any billing, counsel or the due process vendor shall promptly resolve the deficiency so that the JAC can process the billing for payment. The order should reflect that counsel must comply with all JAC policies and procedures in the submission of billing to the JAC for direct payment to a due process vendor. The JAC requests that this matter be set for hearing. The JAC requests to appear through communication. Okay, so they basically want a Zoom hearing, and they object and think that they should be held to the JAC rates. All right, Dad, are you ready? All right, let me see how this works. Let me do it like that instead. All right. Can you check your mic here?
How am I doing?
Good. I can hear it good. Hopefully, everybody can hear you. It's my dad, George Tragos, joining us here to talk about the JAC. I've read through the JAC's motion here. We've talked about how the defense has the burden to show why they should go above and beyond the JAC rates. So let's talk about the JAC a little bit here. What is the purpose of the JAC?
The JAC is managing the funds that the legislature approves for indigent defense. If you're an appointed lawyer, you bill by you have to bill. The JAC pays you because the client cannot pay you because they're indigent. They also, for under due process, and we can explain that, but due process, they also have to pay for experts, transcripts, things like that. So the JAC has a budget given them by the legislature, and out of that budget, they pay the free lawyers and they pay the expenses of a trial for someone who can't afford to pay.
Okay. So, and we're going to talk later about what lawyers get paid in these situations, but just focusing on experts. Why do we in Florida and other jurisdictions even have a situation where the state pays for experts? Why don't they just pay for lawyers?
Well, it starts back with a case a lot of us know about, Gideon versus Wainwright.
Mm-hmm.
And back then, people who couldn't afford a lawyer went to court without a lawyer. And eventually the Supreme Court in Gideon said, that's just not right. It's just not a fair level playing field for someone to go in there, the prosecutor hammers them, and they don't have a lawyer to defend them. So if they can't afford a lawyer, they're saying the Constitution mandates that they have a lawyer appointed so that we can have a fair trial and that they can get a break just like everybody else and have a lawyer at that trial. So since Gideon, there have been free lawyers provided. Then after Gideon, they began to say, you just can't provide a lawyer. But, in a case where you have mental health issues, you've got to provide a psychiatrist. You've got to provide a investigator in certain cases. They need transcripts of depositions. So then they went to the due process clause of the Constitution and said, not only do you need a lawyer, but you also need these things that make it a fair trial that also are required, and they are paid for by the state as well.
Right. So the point is for them to get a fair shake at trial,
right,
and to not mean the judicial system, if you're poor, you're automatically convicted. Because if the state has all these experts and the state has lawyers and you're up there by yourself with no lawyer, no expert, you're going to get convicted. I mean, most lawyers could convict innocent people if they were representing themselves, if they had just even enough for probable cause for a judge to say they can go forward on these charges. So that's why we set up a system that's fair. But it can't be unlimited funds. And we've been talking about how it can't be unlimited funds. And so how do they come up with the amount of money that they pay or that they allow for experts? Let's focus on experts for now.
Well, I think you've got to start with the total budget. How does the legislature come up with a total number to give the JAC? And it's just like anything else in the legislature. It's back and forth, it's negotiation. There's no logic to it a lot of times. They just come up with this lump sum and they give it to JAC. JAC then has to come up with guidelines. Some of the money goes to attorneys, some of it goes to investigators, some of it goes to experts. They have these guidelines, and you've seen, I know you've talked about it, that the guidelines would be violated if they paid the amount of money that Mr. Bankowitz wants here. Therefore, the JAC has a right to come in, challenge what Mr. Berskowitz wants, that they have standing to do that. Was it Bankowitz?
Bankowitz, yeah.
Bankowitz, I'm sorry. Mr. Bankowitz wants, they have standing to challenge it. The statute says that. And the statute says that they are presumptively correct, that it's Bankowitz's burden to prove that they are wrong when they say that this is too much money.
A lot of times they do, to give the legislature a little bit of credit. They try to look at what the rates are in the community, how much can they pay. They're not going to pay for the most expensive person, but they want to at least make it enough to where you can find a competent person charging that. They're not going to say $15 an hour for an expert because they know you can't get any expert for $15 an hour.
But it is just a guess, because there have been times when the JAC has literally run out of money, where the year is not over. The money is all gone. They don't have any money to pay experts anymore. So sometimes experts work hoping that in the next budget, there'll be enough money to pay them for the money they did last year.
And people ask every time there's an ex parte in the title, meaning basically like one person can ask the judge to do something without the other parties there. How would you define ex parte?
Basically, ex parte means that it's not a public hearing, that some people are excluded from what's going on.
Basically, the judge can make this decision without all the parties there.
Or only one of the parties.
Right. Which that would, yeah, right. Like JAC is saying they can handle this because they're objecting to it. And I guess the state doesn't really have to be involved in this, right? The state attorney.
They really have no dog in this fight.
Right.
It's the JAC's money and it's the defense lawyer. That's all that's involved.
I think you might be frozen unless it's my.
Oh, it looks frozen on yours. Yeah, I can see.
I look frozen?
No, I look frozen even
That's
on my
okay.
camera.
All right, let's keep going. Gerald asked if she's found guilty, will she have to pay the money back? So they'll have like court costs and fines and stuff, but they never end up paying all of it.
No,
back.
they don't.
Gloria, welcome to the membership crew here. And Lori. Oh, here's a good one. Rebecca, do expert witnesses upcharge when it's a high profile case?
On indigent cases, they really don't upcharge because they know they'll be lucky to get the money that they're asking for. A real expert knows how much the JAC pays and they know what the guidelines are. And most of these experts, one of the things I think it says in the motion, these are not people who have contracts with JAC. Most of these experts already have JAC contracts, so they already have agreed to pay the hourly rate the JAC wants.
Right. And we're going to look a little bit at the contract Bankowitz signed as like a court-appointed lawyer. M. Lebrecht said, love design on the shirt, Peter, especially the purple. Thank you. Sarah, can the court/judge say that the defendant's expected defense reason is completely ridiculous and deny a motion for specific expert? Thanks, guys. So it does talk about in here how they have to explain why they need this specific specialty. They explain why they might need somebody that's a little bit more, but they actually have to show reasons why. Have you ever seen a case where a judge says, oh, this defense is total BS, so you can't hire this expert?
Yes, I have, or I've seen where, and again, in this case, it's one of their arguments. You already have one expert. You don't need two. You already have what you need. It's not only that the expert is needed, but that if I denied the expert, you'd be denied due process. So you can show that you need an expert, but if I deny it, will that deny you due process? And again, if you already have one expert, why do you need two? That's a question.
Especially in cases where defendants are asking for stuff that's unreasonable, like if there's 1,000 hours of tapes and they want an expert to go through and show how each of those tapes have been, chopped up and edited when there's really no evidence of that. And, there are times where they will deny it. This usually isn't one, right? I mean, they're going for a battered spouse syndrome. Thank you, Lori. And so to have a mental health expert testify about that is a very important part of the defense. So that's not what's going to happen here. Now, the big question is they already had a mental health expert that the JAC allowed $7,500 to be paid to. So how does that work as far as how do you think the court's going to look at another $15,000 for a new expert when they already paid $7,500? And then to add the wrinkle of she has now had 6 and going on her 7th lawyer. And the previous expert was working with the previous lawyer. So how's the judge going to juggle all of these interesting issues in this case, and what kind of decision you think they're going to make?
Well, I don't know if it was Mr. Bankowitz or the attorney right before him, but one of the last two attorneys did go to 3 experts, and all 3 of them said they wouldn't testify for the amount that the JAC was willing to pay. I don't know if the one mental health expert they had, if they're qualified in this area. Have they been an expert in this area before? Have they testified in this area? That's a big question here, is whether this other person would really qualify as an expert, or do they need a person specifically geared toward this particular defense?
Okay, John, put the first poll up there. That is $15,000. I think I'm coming through as an echo on your computer, Dad. I'm going to pull you off, Dad. Why don't you restart because you're frozen anyway? Restart and then come back in.
Okay.
All right. So we're going to do the first poll, which is $15,000 total. I don't know, however you want to word it. Too much or too little or just right for an expert. So what Bankowitz is asking for, $15,000, is that too much? Thank you, Belinda and Marty, for the super stickers. And as you're answering that question, I do want to scroll down and look at what they attached, which is the contract for payments relating to attorney services provided to indigent defendants that Frank Bankowitz signed off on and agreed to be a part of, because that's, I think, a big part of, the issues between Sarah Boone and Bankowitz. He's not a public defender, but he did agree to be appointed to these cases and not necessarily be picking and choosing his clients like a private lawyer might. And I want to read a couple of the paragraphs here. So the services. Attorney contracts with JAC to provide legal services for indigent persons constitutionally or statutorily entitled to the appointment of counsel for the categories of cases as provided by the Florida statutes and the General Appropriations Act. JAC shall not provide compensation for any category case not listed in the Florida statutes and the General Appropriations Act. Attorney shall not seek compensation or reimbursement by a JAC for fees, costs, or related expenses, except for those categories in the cases specifically delineated by the Florida statutes. Attorney shall personally perform the legal services required for the case. Attorney shall at all times, okay, so here's the interesting parts, at all times comply with all requirements of the Florida statutes, the rules of professional conduct, and the rules regulating the Florida bar, and the practice and procedures of the Florida state courts. Attorney may not reassign or subcontract any appointed cases or portion thereof to another attorney or bill for work performed by another attorney. This limitation on subcontracting, reassigning, or billing shall include associates or partners of attorney's law firm, regardless of whether the associate or partner is on the registry. Attorney affirmatively waives the right to seek compensation for work performed by another attorney. Attorney shall not bill for work performed by a paralegal, secretary, or other similar clerical office support, legal assistant, admin assistant, or any other employee of the attorney's law practice. Attorney shall not bill for clerical or secretarial work or work of similar nature performed by attorney. So it's like if you do certain work that should be categorized as secretarial work, you can't bill for that. If you have a secretary that does work, you can't bill for that. You can only bill for attorney work. Now, if we have an hourly contract, sometimes we have in there, here's what we're going to bill for a partner. Here's what we're going to bill for an associate. Here's what we're going to bill for a paralegal. Here's what we're going to bill for a legal assistant. Those types of contracts, if it's private, then you can do it. But in this situation, you can't. Paragraph 3. Attorney shall provide to client all professional legal services reasonably required related to the case related pending matters from the time of appointment through conclusion. When appropriate, attorney agrees to file notice of appeal and to take such other action that may be required to protect the client's interest in accordance with the Florida rules of procedure. So again, we're thinking about, as we read these, the complaint Sarah Boone made. He wasn't talking to her. He didn't give her he gave her cell phone number, wouldn't call her back, wasn't sharing discovery with her, wasn't prepping the case with her. Months would go by with no communication at all. Paragraph 4, attorney shall provide competent representation to the client. I think she may argue he didn't do that. Paragraph 5, except as provided in this registry contract, attorney agrees to complete all cases assigned to attorney, even though completion of the case may occur beyond the term of the registry contract. Unless the court discharges the attorney or allows the attorney to withdraw, or the attorney is deemed to have withdrawn upon the client's retention of private counsel, attorney shall complete the case to final disposition. If the attorney seeks to withdraw from a case, attorney shall serve JAC with the motion to withdraw. Compensation for cases that remain open beyond the registry contract shall be subject to this registry contract unless superseded by another registry contract. Okay, we don't have to get into that. But generally speaking, this is what he agreed to. And this is what he agreed to do. D. Trug asked, in the JD trial, Dr. Hughes was more expensive than Dr. Curry. More expensive doesn't mean better. I agree. Not always. Not always. But there are lots of situations where you do get what you pay for. Rebecca, who defines a witness is good enough? Well, there are different ways to determine competency. If you're licensed, board certified, have testified before, have been certified as an expert, have testified in other cases, then usually you're found to be competent. That doesn't necessarily mean you are the best, but it may mean you're good enough. All right. Is that better, Dad? Let's check the mic.
Testing 1, 2, 3.
Nope. I'll remove you to restart again. My mic is all messed up. All right. Sorry about that. Purple Panda, thank you for the super sticker. Jerry, they are saying they can't find another expert. Does that have any effect on what the JAC would cover? My dad will answer this one because I talked about this with him earlier, so I kind of want to hear what he says about that. How much does the prosecution get for experts? It's another one I think he should answer. So this expert still gets paid even if they aren't hired due to the situation. Yes, a lot of experts do get paid even if, I don't know what you mean by hired, if that's necessarily the right question, but they can be retained and used on the case and not testify and still get paid. Yes. All right, let's test it again. Hold on, I'm going to unmute you. Or you have to unmute yourself.
Testing 1, 2, 3.
No.
Testing.
No. Okay. All right, let's just keep going. Nirvana, the 6 other attorneys were already paid before she dismissed them. So if they work for the public defender's office, they're paid because they're paid a salary. But hold on a second. They're paid because they were paid a salary. If they're appointed lawyers, they're only paid for the hours that they work. And I do want to get into that because that's an interesting point of the discussion about how much these lawyers get paid. So Jerry, I'll just answer this one. They are saying they can't find another expert. Does that have an effect on what JAC would cover? Yes. If this is the only expert that's competent to testify in the specialty field that they have, then yes, that would affect how much the judge could order the JAC to pay or try to order the JAC to pay. Because it's always interesting, if the JAC doesn't have the money, the judge can't really force the JAC to pay money they don't have, right? But yes, absolutely, if this is the only expert that they can find to do this, then that will have an effect on how much the JAC will pay. Belinda has a question for Papa Tragos. We'll wait till he comes back for that. Marty McFly, equal defense pay to state should be the law. Too many people are overmatched by overzealous prosecutors and DAs, and that is not fair. So I agree with that. I do think it should be a very similar number, but we'll kind of talk to my dad about how the state gets approved to pay for experts versus how the defense gets approved to pay for experts. Rebecca, I think it does matter if she is fishing for a specific mental defect. However, I believe that she is entitled to the best she can get. So I agree with you, and that is something that the court won't allow. Now, private attorneys and experts, you can have 1, 2, 3 people evaluator and, pick which one might be in line with your defense. But the JAC is not going to pay for 5 different experts to evaluate her until they find one to say what they want. That's not how it's going to go with the JAC. Dad, did you check it with John? Is it good? Just give me a thumbs up if it is. Okay. All right. Let's try this again.
Can you hear me?
Yes. Okay.
All right. Okay.
All right. So we're back. A couple questions for you that came in. Belinda, question for Papa Tragos. Would you ever consider representing Sarah Boone, and do you think her case is winnable? Do you know about the case specifically or no?
Excuse me?
Do you know about Sarah Boone's case specifically?
Yes.
Okay. So go ahead, answer the question.
I would consider representing her. Yes, it is a winnable case. And I think the most winnable thing about it is, apparently, from all the evidence, he voluntarily got into that suitcase. And now you might not be able to get her off of a manslaughter, but I think murder 2 might be a winnable case.
And I think she really buries herself with some of her own comments. I think if she wouldn't have said anything, it would be a lot more winnable than it is now.
Right.
All right. Talk a little bit about, we've had a couple questions about how the prosecution gets funding for their experts versus the defense. And do you think that's balanced and fair? So how much does the prosecution get? Where does that come from? And is it fair if they get to call more or have more funding than the defense does?
Well, the prosecution has a prosecution budget, and each state attorney's office has their own individual budget. But I've never seen a situation where the prosecutor wasn't willing to spend whatever it took to win a case. So no, is it fair? No, it's not a fair system. The prosecution has a lot more leeway than people who have to apply to the JAC. Not private lawyers now, but these are the JAC situations, which can be extremely unfair.
And it's funny because everybody talks about and judges talk about and the law is written to protect the rights of the criminal defendant. But at the end of the day, we put a lot more resources, time, and money behind prosecuting criminal defendants than we do defending them, which I think most people will be okay with. But it's just interesting when we think about this. These are the types of reasons why we stress so much presumption of innocence, beyond a reasonable doubt, a fair trial for the defendant. That's why the prosecution has basically unlimited resources while the defense has $150 an hour for the expert, as good as that can get you. When in reality, this was a private client. I mean, most of our experts are in civil cases. They're $600,000, $700,000, $800,000, $900,000, $1,000 an hour people and experts. It's not uncommon at all. That experts can cost $10,000, $20,000, $30,000, $50,000. And the defense side, forget about it. Over the last 3 years, there's a discovery question that we get to ask defense experts, and it's very common that they have been paid 7 figures, over $1 million to testify for the defense over the last 3 years for insurance companies. So tons of money is an expert testimony. Azam, Peter, how much does it actually reasonably cost for an expert or all the experts for each party? Well, it depends. I mean, a lot of times you go through trial and you hear how much you've been paid on this case, $15,000, $10,000. So every case is really different for the total amount. But as you see here, they've already paid $7,500. They want to pay another $15,000. If the state is going to have corroborating experts, I would expect it to be at least that much. But every case is really different. But when you listen to when they ask that question for bias, how much have you been paid to testify today? And you add it all up, you can start to figure out exactly how much they pay. All right. So now I want to take a second before we. So John, star some questions for me so we can answer those at the end. So before I put the statute on the screen, for the chat, there are 4 different categories here about how much the cap is for a court-appointed lawyer to get paid in Florida. The first one is for misdemeanors and juveniles. The second one is for non-life felonies. The third one is for life felonies represented at the trial level. And the fourth is for capital cases, meaning death penalty cases. What do you think the cap is on the amount of money that a lawyer in this situation, Sarah Boone's situation, so it's a life felony, but not a capital felony. What do you think the cap is? Put the number in the chat. Okay, so the cap.
Actually, the better way to say, I think, it's a flat fee. So what
this
is
says
the
statute says the compensation for representation in a criminal proceeding shall not exceed the following.
Right, but the JAC has done from starting July 1st of 2023, they're calling it flat rates, and to exceed the flat rate, that's when you have to file a motion.
I'm looking at the 2023 Florida statute.
Okay, I printed this off the JAC website.
I'm going to go with this. I'm pretty confident this is right. And these are numbers that and you can tell me if those are different, but we're just going to put on the statute here. All right, so here we go. I like it. So we're talking non-life felonies. So I'm getting some numbers here in the chat, which is good. 25,000, 25,000, 5,000, 50,000, 30,000, 70,000, 75, 25, 0, somebody said. 35. Okay, so the vast majority of you think it's somewhere between 25 and 75,000. A couple of you think way lower. Some of you are saying 200,000, 100,000, 7,500. But I think 25,000 is probably the most common number. Okay? So now let's kick it up a notch. For the most serious of cases, capital cases, what do you think the number that it will not be exceeded, or the cap that they would pay a lawyer to handle a capital death penalty case in Florida? We've talked about death penalty cases, how much harder they are, how much more time consuming they are. We heard lawyers saying basically, I can't handle any other case because I'm handling this one death penalty case. What do you think that number is? All right, so some bigger numbers coming in: 150,000, 75,000, 250,000, 125,000, 250,000, 100K, 200K. So this one, everybody's basically saying 6 figures, if not multiple 6 figures. All right. So let me pull up the statute here. You probably can't see this, but I'll read it to you. So the compensation for representation in a criminal case shall not exceed the following. For misdemeanors, meaning the lowest level cases, $1,000. For non-capital, non-life felonies, $6,000. For life felonies represented at the trial level, which is Sarah Boone, is $9,000. So dealing with Sarah Boone, dealing with all of her communications and letters and having her send out investigators and trying her case and fighting for her is $9,000 is the cap. And that's only if you bill up to $9,000. And then capital cases, which are the most significant and most difficult cases, $25,000. That's what they give. Somebody said, now I know why he left her. So what does the JAC say as far as flat rates?
Well, they say a flat rate on a life felony is $5,000, a punishable by life felony $2,500, and a capital murder lead counsel $25,000.
So yeah, so similar numbers, but it sounds like the flat rate you start at 5, but maybe you can go up to 9 based on this Florida statute because this is a not exceed amount. Okay, so okay, I don't like the way you worded this one, John. Is $15,000 too much for an expert? Yes, and people said no. So it's not about is it too much for an expert, but for Sarah Boone's case. Okay, so I'll tell you how to write this poll. So poll number 2. Do you think $9,000 is enough for a lawyer to represent Sarah Boone in this case? Yes or no? Do you think $9,000 is enough? Because that's really the cap. How does it work with multiple lawyers? I would assume that each of them can bill up to the $9,000, or is it per case, or how does that work?
It's per case except for murder. On
So,
murder
so you're saying that all of these 7 lawyers combined can only bill up to $9,000?
They're going to, the way the JAC words their contract, yes, but my guess is they're going to get an extraordinary fee and that they're going to get more. But technically speaking, on a normal case, if one lawyer starts, leaves, another lawyer takes over, they split whatever the fee is for that case.
Yeah, I've never done court appointment work ever.
And full disclosure, because of this, because I've represented people for free because I'd rather represent them for free than represent them the way that JAC wants you to represent them.
Explain why.
Because first off, let's face it, you got a life felony, what, $5,000? Well, at 100 hours, at $100 an hour, which is far less than we charge an hour, that's only 50 hours worth of work. Come on, 50 hours worth of work to represent. So I might as well do it for free. The other is, how much time does it take you to do all the stinking paperwork for an expert? You not only have to file the motions, you've got to talk to 3 experts to get all their prices. You've got to contact JAC, you got to argue with them. They have so many days to challenge it. If they challenge it, then you got to have a motion. Then you got to go to court. Then you got to have a hearing just for one expert. You have more than one expert. You have an investigator. You got to do that for every one of those. And then at the end of the case, if you want more than your $5,000, you've got to go through hoops like you wouldn't believe for JAC to pay another $2,000 or $3,000. It ain't worth it. I'd rather represent it for free, which we've done on occasion, rather than this JAC. And that's why they have trouble, by the way. They have real trouble finding lawyers to do JAC cases, especially murder cases. Sometimes they have to bring lawyers in from other counties because some counties have nobody that wants to work for this on a murder case.
And that's the issue, right? And that's why this complaint about this lawyer never calling her, never visiting her at the jail, never doing any work on the case. You start to see some of the issues, right? And he'd much rather, and we kept talking about, he's going to this, he's got a capital case. He's just going to be working on that. Well, if you can make 25 grand work in a capital case or 9 grand work in this case, you're probably going to prefer the capital case. They probably would rather get the capital cases, right? I mean, they'd rather get the ones they're going to get paid the most money on from their perspective, because it is what it is. You're going to just go work on a case. So to me, it's tough. It's really, really tough. A couple of interesting questions came through though that I wanted to get to. Jessica asked Peter if she can't get an adequate expert witness and she loses her case, can she appeal on that? So yes, she can appeal on it, but not having the funding is usually not going to be a winnable argument for the most part. Patty P. So this potential new expert has not previously agreed to JAC rates.
Yes, that's in fact, that's, I think that was said in court, even that doesn't have a JAC contract, right?
Do public defenders have the same caps and JAC rates that they have to get for experts?
Not necessarily, but they have funding issues as well, and they have to be careful that they don't overspend their money. It's all a matter of dollars. I mean, that's what this really comes down to, is if it's coming out of these, tax money out of the taxpayers' pockets, then there's limits.
And that's just the reality of the situation.
Right.
Gingy Probs. Hey, y'all, caught alive. Boone, presuming she's innocent. It's amazing to me how much of this she brought on herself by not staying quiet between her interview, letters to the court, etc. Yeah, she's definitely not making it any easier on somebody to represent her. That's for sure, with exactly what your comments about.
I think, again, I read somewhere, is this her 7th lawyer?
Yes.
Okay.
But she explained in one of her letters, there were like conflicts or the lawyer couldn't handle the case. So a couple of them went through really quickly. I think she had one real lawyer before Bankowitz. Bankowitz was number 2. Doesn't sound like he did much. And so she's on, it seems more like number 3 than 7, but still not great. Heather Coyne, welcome. All right. So let's get into this. This was the last thing I wanted to kind of talk about. Christina asked, good question. How much is Ann Taylor getting paid? So another capital case we know about in Idaho has a public defender on it, Ann Taylor. For the most part, public defenders get whatever their salary is. But Ann Taylor, as we saw in the Alec Baldwin case, they asked the legislature to give them more money to prosecute Alec Baldwin because they knew it was going to be expensive with experts and things like that. And they needed more of a prosecution budget, like what my dad was talking about in the beginning, how the prosecutors usually have budgets. And Taylor also asked the county for more money, and it was approved to the tune of $200 an hour for Ann Taylor, which is, they based it on a 40-hour work week because she said she was going to be working overtime and things like that. So basically 200 times 40, $8,000 a week, which is over $380,000 a year for what in Florida is potentially capped at $25,000 outside extenuating circumstances. And not just that, but her second chair lawyer, the lawyer assisting her, is $180 per hour. And investigators are $45 an hour. So think about the money that is being spent by the Idaho taxpayers for Brian Kohberger's defense. That is wild. How different one state to the next can be for public defenders and court-appointed lawyers.
And think about it. How many taxpayers do they have in Idaho compared to how many taxpayers they have in Florida? Think what you could probably portion that out per taxpayer in Idaho because they don't have that many people living in Idaho. And it would cost every taxpayer individually out of their pocket money to defend him.
It's wild. Zach Kennedy. Wow, Florida is cheap. Timothy Jones, South Carolina, who killed, did insanity defense and state paid $15 to $30K per expert, and he had like 3. Melanie. Is it possible that this is a reason why she's having difficulty keeping lawyers? I could see her asking for an expert and a lawyer saying there's not enough for that and her getting upset. So it's not the same bucket that comes out of expert money and lawyer money. And that's the frustrating thing, right? If a lawyer is annoyed at how much he's getting paid to represent Sarah Boone, it's on him because he knows what it is before he signs this document that we saw Frank Bankowitz sign. Pete back in the day had a couple like federal court appointed lists, which is very different. But you know what you're signing up for, and you don't sign up for it unless you're going to accept these appointments. And so if this is wrong on the lawyers, if they're leaving because they're not getting paid enough money, it's not like you agreed on a private contract for $250,000. Your client pays you $50,000 and then they stop paying you. That's different. They breach the contract. They stop paying you. That's not what this is. You know what you're getting into when you sign up for this. Niche craft. Wait, can you remind us what JAC stands for again? Probably a silly question. Yes, it's the Justice Administrative Commission. That's what it stands for. And if you look back to the beginning of the video, when I play the actual, or when I show the actual document, it's on there. Rebecca said, thanks for the info, guys. Go Cowboys. All right, let me say here. Al says, my attorney charged me $9,000 a month for a retainer. Yeah, $9,000 to handle this case is
900. 900.
Oh, 900. Sorry. $9,000 for this case is low either way. Okay, John, do you want to send me the latest poll results before we finish? JS said she treated Bankowitz like a dog. That's why he didn't want anything or want to do anything for her. I get it. I get it 100%. But if you ask any lawyer, you sign up for court-appointed list or you're a public defender or even a state attorney, you work through some difficult situations, but that's what you sign up for. That's part of the mission. And you do your best regardless. You don't screw a client because they're not nice to you. I mean, that's just not, right. Any lawyer will tell you that, especially a criminal defense lawyer. Summer, Papa T, represent Sarah Boone so we can watch you try a case on TV. You're the best, even though your alumni murdered mine. Go Tigers. Oh, she's talking about Florida State. All right, so here it is. 79% of you said that you think $9,000 is not enough to represent Sarah Boone. I can't believe anybody said it was enough. But yeah, so, all right, that's all we've got for this one. Let me make sure I got everything. Last couple questions in here. Yeah, so that's all we've got for this one. Interesting look into how court-appointed lawyers are paid, how court-appointed experts are paid, or experts for indigent clients are paid that are not using the public defender's office. How state attorneys have different funding and they're experts. So hopefully you guys learned a lot. Hopefully you enjoyed it. Hit that like button on the way out if you did. Until next time, we are out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed this episode, please hit the thumbs up and share with your friends who might be interested here on YouTube. And of course, don't forget to subscribe to our channel. You can also follow us on all social media, Twitter, Facebook, TikTok, at Lawyer You Know. But on Instagram, we are still at Tragos Law. So look us up on there. And don't forget to listen to the Lawyer You Know podcast, available on all major podcast platforms. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us lawyeryouknow@gmail.com. Of course, all of these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, the Lawyer You Know.